Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited for this after-action review, where we'll be sitting down with Megan Burns and Emily Dahm from Mirador Law.
The case of Maria and Esmeralda was a case that came to our firm through a referral through my network. And basically what happened was about a series of bullying events that had taken place at James Logan High School for approximately a year. The school knew all about it. They had never notified Esmeralda's parents as to what was going on. Eventually, the bullying escalated to the point where Esmeralda was incredibly worried for her own well-being and finally self-disclosed to her parents. And on that day, Maria, Esmeralda, and some other family members went to the school to try to meet with the principal. And as they drove into the parking lot at James Logan High School, the bully and a number of her friends, along with the school's security guard that was a family member, met them in the parking lot and immediately when they got out of the car started attacking them. And you can imagine from an attack like that, there was a very real and visceral experience that they both had with post-traumatic stress disorder.
Let's get to the jury selection and the manner in which you approached the selection process. Was there a strategy that you had in terms of going through things and looking for particular types of jurors?
Well, let me just jump in and say that I'm going to leave this question to Emily because she did voir dire. But before she talks about her strategy for voir dire, I do need your listeners to know that Emily Dahm gives a masterclass in voir dire. And so that's the beauty of having a law partner that you have so much respect for as a fellow number one trial lawyer, is that you know what your strengths are. And Emily has an incredible strength in voir dire. And so I need to give her credit for that, but she can tell you more about her specific strategy.
Emily won't likely acknowledge that.
No.
Is there something? Is there something in particular, Megan, a style or a method or a skill that you want to call out as far as Emily is concerned that makes her so good at that?
Emily and I are both fellow Midwesterners. And so that maybe tells you a little bit about, what our Constitution is. And I think what makes all great trial lawyers is that you really feel comfortable in your own body and you really feel comfortable talking to people. And Emily is also hilarious, and she has all these kind of hilarious Midwestern sayings like, I bet dollars to donuts. I don't know. I could probably think of 10 more if it came to mind, but she's just incredibly likable and she's funny, and that's just who she is personally. And so having that kind of lack of fear of getting up and just being yourself in front of others is really what is critical to picking a jury. If they believe that you're being earnest and honest in yourself with them, they're going to do the same. And that's really what voir dire is about. It is not a exercise in talking, it's an exercise in listening. And so when they feel that they have the space and comfort to be able to talk to you honestly, that's when magic happens in voir dire, in my opinion.
And with that, let's kick it to you, Emily.
Yeah, so I'll start disabusing all of your listeners of all the things that Megan just said about me. And I will tell you, I've had some real whiffs on juries I've picked as well. So I don't always get it right. And there is even a couple of trials where I can tell you specifically what I missed and what I didn't do right in jury selection. And it had a very predictable outcome. And so this just happens to be one of the ones that I think I got right. With an N of 1, I'm doing great. But I don't really have a particular strategy for jury selection beyond stuff I think most trial lawyers are familiar with. I'm a big believer in deselection. I'm not here to get the folks who are my dream jurors to stick their hands up. I also don't get too wedded to them because, we never get to keep them. The other side has peremptory challenges too. But it really is, I try to figure out if I only get to talk about two things with this jury, with the time that I have, what are the two most important things? Who are the jurors who are going to sink us, and what can I get them to say about it? And in this case, that was our bad fact. Our bad fact isn't our clients. We had amazing clients. We had great facts as it pertained to the actual conduct of the defense. So we felt pretty good about all that. There weren't, these, oh, if you find out my client did X, Y, and Z. No, these were just a great family. And it was a real privilege to be able to sit next to them. So that wasn't our issue. Our issue was nobody wants to stick it to a public school district. And I don't want to stick it to a public school district. Like I'm my mom's a teacher. Half the people in my family are teachers, And so like, I don't relish the idea of putting a big verdict on a strapped public entity that exists for the sole purpose of educating children who can't buy their way out of the public school system. And certainly, we were trying this case downtown Oakland, which is where Megan and I live. And, the Oakland public school system is grossly underfunded and under-resourced. And so, this is something that is going to be the forefront and the mind of the jury pool. And it's not just Oakland, almost all public schools, anywhere you want to go, certainly on this side of the tunnel, need more money and more resources. So it really was just about being really frank up front with the jurors about this is my big concern. And I want to validate for them that it's okay. Like this is an opinion that I actually share with you. And it's all about getting jurors to feel comfortable telling me what they think I don't want to hear. And there was one point I remember this guy, by the time I got to him, he'd been saving up. He'd been saving up all the things he wanted to tell me. And boy, he let loose. And at one point I started laughing, not at him, but I was like, all right, keep it coming. I'm like, I asked for this. Let's hit me. What else you got? But I ended up getting a really large number of people kicked off for cause because when it really came down to it, we had a conversation where they said when push comes to shove, if they found that the district was liable, that they would pull their punches on damages because it would just be too hard for them to give these women full and fair compensation, knowing whose pocket it was coming out of. And I got a lot of people to be very, very candid about that.
Two questions on this. And I'm going to object to my question as being compound before I even started. The dual part question is, what do you feel you did that was successful in getting people to be brutally honest? Question one. And question two is, what do you feel that you did to get people to open up to the point where a judge was willing to grant your cause challenge? Did you have a mechanism for that?
I don't know that maybe Megan knows what I did. I don't know what I did. I mean, I think I'm a very blunt person. And I'm very frank with people and I literally invited them to tell me things that I don't want to hear. I'm here representing my clients and I full-throatedly believe in what I'm about to ask this jury to do. But it's really important that this jury is able to be unbiased all the way through, all the way to the point of damages. And really, I think being able to talk about this as a form of bias. And there is a jury instruction that says, the relative wealth or poverty of the defendant can play no part in a jury's decision about what the damages should be. So like this is, and I use that jury instruction. This is something you're going to hear from the court if you're on this jury, that you actually can't do that because it is a form of bias. It's not fair if you find that our clients have been harmed. It's actually not fair to not give them full compensation. And so it is a type of when we talk about bias. Now, I didn't talk to them about it being biased because I think that is a little bit of a lightning rod word and people interpret that. I would, if I was sitting in their seat, as saying, oh, I'm an unfair person or I'm unable to critically think and I don't like criticizing jurors, for being human. But really, when I'm talking to the judge about these cause challenges, outside of earshot of the jurors, that is what I'm couching it at for the court, because that's the language the court understands is this is a type of bias, and biased jurors cannot be. And if jurors have bias, that's cause.
I'm just sitting here listening to you, and I'm having a realization that may be helpful to Miles's listeners, which is, I think, part of the reason why Emily, and I like to think I'm pretty good at picking a jury too, but she's really great at it, really is our experience as public defenders. I mean, when you are a public defender, you got about 20 minutes to pick that jury. And you better pick the 1 to 2 issues that really matter in your case. And not only do you have to get those people to talk to you, those people don't like you and they don't like your client. And they don't like you because you represent your client. You're sitting next to him or her, and you think that person has a humanity that deserves to be seen. And I think that that is a unique background that we have that really helps us being able to talk to people. It's hard to get up in voir dire and have those tough conversations about people being honest with how they feel, but that is by picking jury after jury and having very limited amount of time to do it. And I think that's a luxury that is given to more civil lawyers, that they have all this time to pick a jury. You get your questionnaire, you've probably done focus groups or other kinds of things to get ready. That's not the perspective that criminal defense or public defenders come from. You think about it in the shower that morning as to what your 1 or 2 best issues are, and you scribble on a notepad the few questions that you want to make sure that you cover with the jury, and then that judge gives you 20 to 30 minutes, and it could even be on a serious felony case. And so that's, I think, when I'm hearing you speak, Emily, I'm realizing that that experience that you have really comes from your background picking really tough jurors in criminal cases.
Yeah, I think that's a good point. And yeah, Megan is selling herself short. I've watched Megan pick many juries, and she is every bit skilled, if not better. And I will say a lot of my cases, particularly in private practice, I do a lot of sex cases. So, you walk in the room and, you can almost hear everyone hissing at your client. So, when you walk in with it being the most hated person in the room, or, the jury pool, that group of 100 takes a look and says, oh, what'd he do to be here sitting next to her? Or, no, she's one of those slimy defense attorneys who's going to try and get him off on a technicality or whatever. You are definitely swimming upstream. And so I think that does build a certain resiliency. And also, I think we have that experience, Megan and I both, of picking jurors, and we get that cause back and forth with the jury, and you've got them there. And then the judge comes in and says, oh, but you can be fair, right? And they rehab the hell out of that jury. And so that can be really frustrating. I have a really funny story really quickly. This was a criminal trial where a judge had given the whole, you haven't heard any evidence. If you had to go back and vote right now, you'd have to vote not guilty because these are just allegations. And so we do some back and forth, and it's my turn to talk to this juror. And I said, you heard that thing the judge said about no evidence. So if you had to vote right now, just checking, how would you vote? And she said, oh, I'll find him guilty. The judge, like, are we done here? Do I have to do more? And the judge just jumps in, oh, no, ma'am. And he explains the concept again, and you can't do that. And this is how it goes. And so he rehabs her, and okay, I understand. So then I don't buy this for 1 second, right? And this is another thing I tell jurors, like, I don't have the hubris to think that I'm going to walk in here and in one forced conversation with you, I'm fundamentally changing your worldview. Like, I'd like to think I'm that amazing, but I know I'm not. So I know the judge is also not this amazing. And so he asks, he does that. And I asked this juror again, okay, so you heard what the judge said. Just want to check. If you had to go back right now, all you've heard is the judge just read the charges against my client. If you had to go back right now and vote, how would you vote? And the juror said, oh, well, I'll wait to hear all the evidence. Then I'll find him guilty. And the judge finally had to relent, and that was a cause challenge granted. But yeah, it's hard, talking to jurors, and it's hard. Nobody wants to be there, and nobody wants to share stuff about their thought process and how they feel about usually often topics that they probably wouldn't even talk with their friends and family about in front of a room of strangers, all the while being rated by two lawyers. It's hard.
As we go through this piece, there are a couple of questions that I usually cover. Um, Mini opening or no mini opening?
Love mini opening. I don't understand I'm going to tell you this, I've never gotten one in a criminal trial. Never. I've only gotten them in civil trials. And I love them because let's be honest, like this idea that you can insulate in jury selection, this jury from the facts, like obviously, and I tell jurors this, like, look, a lot of stuff's going to be vague here because, I mean, if me and the other lawyer had our way, we'd love to just preview our case and then say how you're going to vote and be done with it. But we don't get to do that. But I do think giving the jurors some neutral set of facts, some orientation to why we are asking you these questions, because the most useless thing that happens in voir dire is when the jury knows nothing, the court's told them nothing, and you're asking them questions of what do you hear time and time and time again from jurors? Well, it depends. And I'm like, I know it really does. And I can't give you the one extra piece of information that would actually tell us whether you can be fair or not because of this particular, fact. So you get all these useless, it depends, it depends, it depends. So I love a mini opening. I ask for it every time. Usually the other side doesn't want to do it.
The other area that I like to ask about, and Megan, you made reference to this, that civil lawyers oftentimes have the luxury of doing focus groups, either formally or informally. Did you have any sort of focus work for this case?
No. And this, the whole area of, professionals that help plaintiff personal injury lawyers pick juries. I'd say if I have a bias, maybe I don't understand it, but my own 2 cents is that having picked as many juries as Emily and I have in very difficult cases, I dispute that another professional can come into my case and tell me how to pick a better jury. I mean, that's a lot of hubris that I'm just saying right now. And I understand that. But that is maybe just a bias that I have. So, I have, since this trial, used some big data models, which I find the big data model in doing focus groups to be more productive for me. That is something that I feel like I can get some more, I can get some themes out of. Whether you're looking at the big data model for trying to look at what is your damages ask or picking a jury or whatever the sensitive issues might be in the case, I have bought into that, I will tell you. But bringing people in to help us do focus groups or bringing in a jury consultant, Emily and I have never done that.
For those who are less familiar with a big data model, can you unpack what that looks like for you when you're doing those?
Sure. So there are a handful of folks and other more seasoned plaintiff personal injury lawyers than us probably can rattle off all the big players in the space. But basically, there's a handful of companies that will take your facts and they will go out and do essentially focus groups, but for a much wider group of people. They'll actually design questionnaires and they'll send out hundreds of these questionnaires. Usually those questionnaires are going out to groups of people that couldn't be potential jurors. So they're looking at maybe a jurisdiction that's similar to where you intend to try the case, but they don't want someone to sign up to fill out a questionnaire that could also be a potential juror. So they look for similar jurisdictions with maybe similar demographics. And then they are able to then give you predictive models about how people feel about either certain topics. So I don't want to get too far afield, but I did try another public entity case in Contra Costa County in the last 12 months with a very favorable verdict for the clients. And one of the issues that I had was Contra Costa is a little bit more conservative than other Bay Area counties. And I had one of the two women that were the plaintiffs that went to trial in the case, one of them was in a same-sex marriage. And I just didn't know if that was worth addressing in voir dire, because I did voir dire in that trial. And so, there were different questions we wanted to be asked in with the team we were working with to create the data model. But that was one of the very specific questions that I wanted to be asked is this something we should be concerned about? Is this demographic here in Contra Costa, where there are liberal folks, but there's also a lot of conservative folks out there? Is this something I even have to talk about? And, we got some really interesting feedback, which it was a non-issue, which surprised me, if I'm honest. And so I just checked it off my list. I didn't ask any questions on voir dire about, the nature of one of the plaintiff's marriage and whether that was going to matter to these jurors. And I'm glad I didn't waste time on it.
Interesting. And part of the reason I nod and say interesting is, it's probably 2019. We tried a case in San Mateo County, and it was a same-sex marriage with a loss of consortium claim as part of it. And we used a jury questionnaire that was written in a way where if the people were not in favor of same-sex marriage, it automatically would get them kicked off the jury. And we lost 25% of that jury back then.
Wow.
Yeah.
That is fascinating and disappointing.
It was
wow.
Stunning. Absolutely stunning.
Hot damn.
Yeah.
Huh. Well, I have my feelings about trying cases, and I've never tried a case in San Mateo County. I've had the displeasure of being there in criminal court. So you're not improving my bias.
Well, that was a lot can happen in 6 years?
Yeah.
And at the same time, the country has swung for the right during that time.
True.
So,
I've done a couple big data model tests in a couple cases, one that was about to go to trial and one that I actually did try. I've found that information to be very useful. I think when people use big data models to predict what they should ask in terms of the number, I think that is incredible risk. I think that you really need to, I know that there's probably a school of thought on this about getting out right in your opening statement saying, I'm going to ask for $10 million and 25 cents or whatever it might be. There's a lot of people that I've heard speak that say you need to put that number out front and center. Either you need to do it in voir dire, you have to do it in opening. You really need to precondition the jurors as to what you think the reasonable amount should be in this case. I have also done the opposite. This was not a case where we said we are going to ask for $9.5 million in change for Maria and Esmeralda in this case. In fact, I think Emily and I came to the decision of what we were going to ask for within 40 hours of when we gave our closing argument. And I just think each case is different. And so I think the risk with the big data model is when you work with one of these companies, they'll give you predictions as to what your 12 jurors, 25% of the jurors are going to, return a verdict of X. 50% of the jurors are going to return a verdict of Y, and 25% are going to say Z. And I think when you rely on that too heavily, I think that is a real risk for trial lawyers. I think you need to read the room and really make those decisions. In some cases, you can put your ask front and center, especially when you have a big life care plan and you have a bunch of economics, and you're going to walk them through why there's $10 million in economics to start off with. I think those are easier cases to come out front and center and say, this is what our ask is going to be. Well, I think the thing that's unique about this case is that this case was almost entirely non-economic damages. And those cases, I think, are much harder to come to a, group of prospective jurors or to that group of 12 right there in opening statement and say, give our clients 10 million bucks or close to it. I just think they have to hear the facts and see, and you have to read them throughout the trial, which we spend a lot of time reading our jurors through the trial to see how they're reacting to testimony. And then you can decide what they are going to be willing to return and also how well the facts came out for you.
Megan's not telling this part, but I had a crisis of confidence going into, are we going to seriously ask early? This is at opening and quite uselessly and in getting in Megan's way, I had to shut myself up because she was about to open, and I'm like, externally processing, like, I don't know if we can ask for this much money, oh my gosh, I just don't know if it's gonna pan out, and what are we gonna turn them off? And I was like, and Megan kind of told me, shut up. And I was like, oh my God, you are right. You're opening. I need to shut up. And, what's so interesting was not only did I need to shut up and I should have known better, I'm a trial lawyer. When I do criminal defense cases, I talk about I need blind adherence to the not guilty. We are all drinking the Kool-Aid, okay? And if you can't drink it, I can't talk to you, can't see you, can't smell you, can't know about you as an existing part of my universe until this verdict is over, because I need that focus. And how dare I have taken that focus away and inserted this right before she opened. And thank God I did not trip her up. As I said, her opening was fabulous and jurors were already tearing up at that point. But I also started to see the value of this case in very stark terms once the witnesses are talking and you're feeling it. That's the thing about trials, is you can big data model, you can jury consultant all you want. But at the end of the day, it is an intimate experience between the advocates, the court, and these 12 people plus or minus, 2 to 4 others as the alternates. And there is a vibe. You got a vibe check in there. And you start feeling it and in ways that, no data model can tell you when, juror number 3 is giving you the stink eye. And, sometimes you can read too much into that. I've had jurors smile away at me and nod and just tell me afterwards what a great lawyer I am. And they drop my client like a bag of anvils, right? So you can't read too much into that either. But it is a thing you have to feel. It's an organic, unique process every time. And as we started playing that out in this case, by the time we got to closing, I was like, we need to go big. This case is worth every penny of it. And Megan's like, well, welcome to the damn party. She knew it all along.
So a question there is, if part of the jury is cheering up during opening, if the witnesses are as compelling as you're talking about, did the defense's myopia continue the entire time? Did they ever say, hey, look, it's time to pull you in a corner and maybe we should explore some resolution?
No.
There was none of that. And trust me, I've done other civil trials where that's happening in the background throughout the trial. And there's constantly discussions about settlement before the verdict's read. This was not that case. There was a very feeble attempt, mostly because they were compelled by the court to participate in mediation. There was absolutely no attempt made to settle with us during trial. One of the things that we had done in this case is not just issue a 998 shortly before the trial started, but I actually wrote a really detailed letter to defense counsel that went along with the 998 that said, here are the reasons why that I think you are going to lose this case. You are really focused on these issues, and these are the facts that I think this jury is really going to care about. And I also think that this case is incredibly risky for your client, because if they see the facts the way we do, there is a chance for a verdict that's far exceeds our 998s. And we really, as a steward of public funds, and I think I literally use that term, you are a steward of public funds, we would ask you to revisit the way that you have evaluated this case and seriously consider our 998s. And it was really an interesting process after this trial was over to go back and read that letter, because literally sentence by sentence, the best facts that came out were exactly laid out in that letter. I basically gave it the preview of what the trial was like. And so it's unfortunate. I mean, it just happens sometimes that the defense just doesn't see the case the way you do it, and you have to try the case. And you kind of have to have the balls to do that as a plaintiff lawyer. You can't be worried about it. You can't just assume that the case is going to settle on the courthouse steps. You got to be willing to put 12 in the box.
On the steward's point, my understanding is the case is now on appeal. I think you referenced that So they still have not seen the light.
I don't want to get too far into what's happening there, other than to say, we're always here to talk. We're always here to try to settle the case. We always want to do what's best for our clients. And I always think that there's a way to do what's best for our clients and also to maybe benefit the defense in a way where we can soften the blow on a verdict like this. So, we're not unreasonable people. We're always here to talk. And you can't take things too personally in this work. I really believe that. Um, again, coming from the perspective of being longtime public defenders, there's so much animosity within civil practitioners that's hard for me to understand because as a former longtime public defender, I was dealing with the same people all the time. And it's not just you being professional, although that's incredibly important. It's also you just being honest. And sometimes you go to battle and that's okay. I mean, that's where I get, that's where I use my sports background and I apply it directly to trial work. You can go to battle against an opposing team, but maybe somebody in that opposing team is a really good friend of yours and you go out for drinks after. I mean, that's the way you have to think about trial work. So we never take ourselves too seriously or take things too personally. And I think that's really important. I know for myself, when I get angry and I take things personally, I lose focus. So I never want to go there.
I think what Megan said is so important, not just for trial work, but just I think the practice of the law. It is being a person of your word, being decent. It costs you and your clients nothing to be decent and to be kind and to be friendly, and we definitely try to keep that at all times. And yeah, doors are always open. The appellate process is ongoing, but we always leave out the welcome mat for conversations because why wouldn't we? And I agree with Megan. It has been an interesting transition from criminal defense practice, where particularly as a public defender, but when you're going to the same courthouses and you're dealing with the same prosecutors, it doesn't do you any good to make enemies. Sometimes you can't avoid it, in the sense that maybe they've made an enemy out of you. But I mean, the person that you might be, full of incandescent rage about this issue on this case is the same person that tomorrow, or maybe in the same breath, put down that file, pick up the next file. I now need to beg and plead and argue mitigation. And could you pretty please see your way to giving my client this? And so, it just doesn't make a lot of sense to make things hostile. And so I think we really kind of bring that vibe to our civil practice as well. But, it's not always met that way. So I joke that the lawyers are far less civil and civil.
A cruel irony.
Cruel irony. Yes, exactly. We're working to change it.
As we kind of wind things down, are there any either trial moments or takeaways, wisdom that you feel it would be important to share with our listeners from either this experience or other experiences you've had as trial lawyers?
I would say, for me, I am a student of Jeff Adachi. He hired me, he trained me. And one thing has always stuck with me that Jeff always used to say, which is that whenever he got up to give an opening statement, the first thing he did was write the prosecutor's opening statement. That was how he prepared to give them the criminal defense opening statement. And I think that is something that I take very seriously in my plaintiff personal injury practice, is seeing the other side of this case. How would I try this case if I was this other lawyer? And actually, I don't necessarily write out word for word what I think the defense attorney is going to argue in either opening or closing, but I'm certainly constantly thinking of that. I like to think of trial as intellectual warfare, and I imagine the pieces on a chessboard. That's the way I think of being in trial. And so I need to think like my opponent. And that's what Jeff really taught me as a public defender. And I think that's one of the reasons why I've had some success as a trial lawyer is being able to see the other side and then anticipate and prepare for it. So that is, I guess, one of I guess the tools of trial work, if you want to say, that I feel like I've learned over the years. The other thing that I would say is that you have to sit in the storytelling of cases. Storytelling is essential to being a good trial lawyer, and that is also something that criminal defense attorneys are really good at doing, is telling a wonderful, compelling story, even sometimes when the facts are all against them. And I think one of the most powerful moments in this trial actually came in the closing argument. I know Emily thought I gave a great opening. That's great. But, I do think voir dire and opening are the most important parts of a trial. But probably one of the most emotional moments came in closing in this case. And it was really Emily's bright idea. She was arguing liability for the closing, and I was doing damages. So Emily did voir dire, I did opening, and then we split closing, which is what we've done in other trials. But Emily had, getting back to the fact that Maria's young child was strapped in the car seat while she and her older daughter are being attacked, Emily had come to realize that that young child was now almost the age to go to kindergarten. And here, our client, Maria, she had very debilitating PTSD to points where she had been agoraphobic in her home. It was very compelling testimony to hear how this incident had not just affected her physically, but affected her mentally and in her very pervasive PTSD that she was working very hard to address and being unable to do that. How is this woman going to go and be on a school campus to support her young child? And it's not just for a moment in time, it's for the next 12 plus years of her lifetime. There was a moment during closing when I was talking about damages, and I brought that in and I said, that little girl that was sitting in that car seat, she's now 5 years old. And I asked a rhetorical question to the jury, which is, and what happens when children turn 5 years old? And the juror that ended up being our forewoman, she kind of made a sigh, like she looked up at the ceiling and kind of non-verbally said, they go to school. She didn't actually say the words, she go to school, but I could see her mouthing the words, they go to school. And that was a moment in time to explain to the jurors the real cost to our clients as to what they had lost, and in particular, Maria. And those kind of moments, explaining not just, oh, this person has pain and this is how it affects their daily life. You have to go deeper. You have to explain who your client is, and in a much more fundamental level, explain how this incident has impacted their lives. And that was probably, there were a couple of the really powerful moments during the trial, but that was one of the most powerful for me.
It was a moment where you could hear a pin drop in that courtroom. And I don't think even our clients had thought about that quite so bluntly at that time either. Like, it, again, talking about feeling the vibe in the room, that was a moment where the air was sucked out of the room in a way that was really powerful for our clients, because Maria had been a very active parent. She was the go to all of Esmeralda's. Esmeralda was on the color guard. She would go to all the games. She was that active parent who would pitch in and do whatever it took and help out at school. And that was never going to happen for this other daughter. That was never going to happen. And that's a loss for both of them.
Anything else that you think it would be useful for our audience to know at this point?
It was an incredible trial. I'm hoping and really looking forward to a conclusion for Esmeralda and Maria. And I hope it comes sooner rather than later. They deserve every bit of it. And I think it's will be very healing for them to be able to move on. And it's just been, I will say this, it is a wonderful thing to be able to stand up and use your skills, your education, your resources to represent people who are just so incredibly deserving. And I think whether I'm on the criminal side of my cases or the personal injury side of my cases, I've always got the underdog, no matter what. And I think it's a real privilege to be able to represent the underdog, and I think it gives you some resilience and some skills that really, I think, play out well in the trial context. If that's where you've always practiced, and where everything has been hard and it hasn't been easy, and the wind is in your face and, the rain's coming down and you still persevere. And so, I encourage people to do that a lot more.
Well, congratulations on your result. I will say, just learning more about your practice and your thematic approach to how you do things, the legal field is vastly improved by your practice and how you approach the world. So thank you for that, and thank you for your time.
Thank you, Miles. This has been great.
Yeah.
Great.
Thanks, Miles. We really appreciate you inviting us.
Pleasure was all mine. Thank you. And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share this with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.